start off with.
Thank you, Chair. There are discrete questions, and I think they can be contained to clause 4.
Right. Okay, so you're happy with clauses 1, 2 and 3 as printed to be agreed to? All those in favour say aye, those against say no. I call it for the ayes. Clause 4, Member for Hyson.
Thank you, Chair. I think I might have given an indication in the course of my second reading contribution to some discrete issues been raised by the Aboriginal legal rights movement and by the Law Society, the first of which is raised by both of them. So I deal firstly with the issue that's been raised by both. That is the introduction of an objective test, the reasonable person test that we see the subject of the amendment at subclause 8. The ALRM captures it, I think, perhaps most concisely, indicating criminal provisions about action and intent. I might just indicate the words of Chief Executive Chris Larkin in his letter, at least to me, and I expect in similar terms to the government. His letter to me is dated the 1st of October, and he says, criminal law is based on act and intent. In our view, the term ought reasonably to have known has no place in the context of a serious offence leading to incarceration. This is particularly so where there's likely been over-representation of Aboriginal defendants who are of a different language and culture to those of the police charging and courts convicting on a subjective reasonable person test. And the proposal of the ALRM is to replace with recklessly indifferent instead. So perhaps in the circumstance of those representations having been made, just put the question to the government in terms of its consideration of that particular matter and why it's favoured the application of the reasonable person test.
Minister.
Thank you. Thank you very much, Mr Chair. And thank you to the member for the question. I certainly welcome the views of ALRM and Mr Larkin and do assure them that we have thoroughly considered those views, and we have landed in with the clause that we have for a couple of reasons. Firstly, because obviously, as is always important to do, we've considered this particular matter in the context of what other jurisdictions do, and it's certainly, this provision is consistent with a number of other jurisdictions. But also, we are of the view that, I guess, the provisions around ought to have reasonably, or ought reasonably to have known, would indeed take account of a particular context and a particular set of circumstances.
Member for Hyson?
Now, take that then just one step further, and that it deals with then the second part of the ALRM's proposal, seeking to ensure the ALRM styles that, by way of legislative guidance, measures to ensure courts take into account the realities, and I'm quoting here from the second part of the proposal, realities for Aboriginal and Torres Strait Islander peoples in considering any reasonableness tests, any imputed intentions, and any notions of recklessness. So I just invite the Minister to add anything about what further steps the government might take in that regard, if any.
I think that we're in alignment here in terms of that intention of the government with that provision to, as I articulated in my earlier answer, to take account of those contexts and circumstances. And as the member is well aware, of course, in any particular hearing, etc., on a matter pertaining to an alleged breach of this Act, through submissions, etc., of course, a person's particular context and circumstances will be taken account of.
Member for Hyson?
I then turn to the issue that's then more particularly addressed by the Law Society, and this time it's by way of a letter to the attorney dated the 12th of June 2024. As I said at the outset, the Law Society also addresses this, the reasonable person test, and adopts a view in line with the ALRM in that regard. Law Society also addresses concern about the threshold in terms of seriousness, and I won't stay to address that further, but the government's certainly made clear it's charted a course in that regard. The point I would raise is that in the final couple of paragraphs of the President's letter to the attorney, and really encapsulate paragraph 17, where the Criminal Law Committee has suggested that conduct that's otherwise caught by this now broadened provision be subject to an express defence around a reason for doing so, the way the Law Society has described that as a reasonable excuse. And one might say, well, common sense ought to prevail, and we know that there are all sorts of circumstances in which means, electronic and otherwise, are used to monitor family members and so on. And I just highlight in particular the Law Society's concern that we're talking about criminal provisions that have tests that are the subject of the legislation, and without express reference to a defence of this kind, it may be that there are these unintended consequences that on the face would constitute the offence without catching the intended conduct. So just give the government an opportunity to address that in the, for the purpose of the record in the committee.
Thank you to the member for his question, and it's, I think it goes to an issue that I could speak for days about. I won't, but I think what the member highlights is that in relation to this particular piece of legislation, but also any legislation, any policy discussion that we are currently having as a state, and indeed globally, we are constantly in this new environment where we are balancing the very positive things that new technologies can do, that they can provide, the ways that we can access information, the ways that we can stay connected to people. We are constantly balancing and deepening our understanding, and I'm saying this in a much broader context than this bill, deepening our understanding about those important opportunities technology can provide, with the fact that it also creates risk in terms of how it can be used to harm people. So I think the area that the members touched upon is very important, and it's one that I have no doubt whatsoever in the course of community debate about all sorts of issues, we will continue to contemplate. And on that note, I do congratulate the new Assistant Minister in our government, Mr. Michael Brown, who will focus, I'm sure, in his duties around artificial intelligence and digital economy about how we do continue in every area of life to get that balance right. And I congratulate him again on his elevation, and I look forward to working alongside him around, again, these opportunities, but also some of the worries that this access to information and technology create. I welcome the Law Society's submission. I thank them for it. And what I would say more specifically in relation to the subclause 8, or 4.8, is that with the example that the member gave, should, amongst a family, with everybody consenting, they be connected with each other through their technology and know where each other is, and there's absolute consent about that. I can't see, as long as there is that consent, as long as everybody is happy to be part of that technological environment, it would be less likely that that would cause physical or mental harm or serious apprehension or fear. What this particular clause assists us with is those circumstances where the technology is not used for that purpose that the member spoke about, that I've just spoken about further, but rather where it is used in a way that will cause that physical or mental harm or serious apprehension or fear. So in terms of the unintended consequences question, I don't see that in that context, in a family where there is that consent, where everybody is part of that particular technology, where everyone is communicating in that way, I can't see that that would cause serious apprehension or fear or physical or mental harm, unless there was something else going on, which of course we want to capture that particular behaviour that does cause that physical or mental harm or apprehension or fear.
Any other questions? No? Well, I'm happy to give you one more. No? All good. I thought we'd try to start the year off in a really good collaborative approach. Okay, the question before the chair is that clause 4, as printed, be agreed to. All those in favour say aye, those against say no. I declare it for the ayes. The question before the chair is schedule number 1, as printed, be agreed to. All those in favour say aye, those against say no. I call it for the ayes. And the question before the chair is that the long title, as printed, be agreed to. All those in favour say aye, those against say no. I now report to the...
Committee considered the bill and agreed to the same.
Yes, consider the bill and agree to the same without amendment. Minister.
Thank you very much, Mr Chair, and thank you to the officials who've been here and all who provided input and advice on this bill. I now move that the bill be read a third time.
Is that seconded? That's seconded. You wish to speak? Member, yeah, member for Highson, that's fine.
Just in addressing the third reading, briefly just look to summarise those matters of focus, the subject of the committee, and I suppose where the bill leaves us in terms of the clause 4 sub 8 application of the reasonableness test. There's now kind of a fairly heavy reliance on what the interpretation of that reasonable person test is going to constitute. On the one hand, the ALRM and the Law Society have provided an alternative, having raised the concern about the centrality of act and intent, as Chris Larkin has put it, and then at the other end, the Law Society has highlighted that in these circumstances in which much of ordinary day-to-day life is increasingly reliant upon particularly electronic means of using technology to assist us in all sorts of reasonable day-to-day ways, that the inclusion of an express defence would assist to alleviate concerns about the offence being constituted by actions that ought not properly be the subject of this new legislation. So I just flag that aspect in particular. This is new territory, as the Minister's indicated. There is a necessary appreciation of the new and ever continuing evolving nature of the use of technology. We use it in many ways for beneficial purposes. There is a considerable amount of room for the use of technology in particular to have one character perhaps at one time or over a period of time, and then change to another. And similarly, there is the possibility for those involved to take a different view about the benefits and purposes and otherwise of the use of technology from time to time. So it's clearly an area of concern. It's important that this be monitored for unintended consequences, and I certainly just indicate again my appreciation of the careful and thoughtful engagement by both the ALRM and the Law Society on those and the rest of the contents of the bill.